that I think is on everybody's mind right now. January 1st is coming really fast. As Heather mentioned, my name is Darlene Wu, and I'm part of the Human Resources Advisory Group for the South Shore Chamber. Very excited. We have two amazing presenters today to talk about PFML. We have Pamela Sande from HR at Work and Nan O'Neill from Murphy, Hesse, Toomey, and Lehane. They're going to walk us through all of the challenges I think we're all facing regarding PFML. And at the end, we'll certainly have time for some questions and answers. So with that, I'm going to turn it over and let's get started.
Thanks, Darlene. Thanks. And good morning, everyone. So as Darlene said, we are going to walk you through some of the PFML challenges. And Pam and I are sort of going to tag team this morning. We'll go through the slides that hopefully most of you had an opportunity to get in advance. And then, as Darlene said, we'll answer some questions, or I should say, try to answer some questions at the end of the presentation. But we'll give you the information as we know it now. And I think before I get started with the agenda here, I just want to say that at least with respect to a number of our clients, and I know Pam is having a similar situation, one of the first questions we're getting, actually, I was just talking to a general counsel of a very large company yesterday, is this really going to happen? And I think all of us, right now the answer to that is a resounding yes. And I know that most employers have been challenged for the last 8 months or so, with COVID and the Families First Coronavirus Response Act and all of the other, legal implications of that. And yes, this is coming fast and furious for January 1st, 2021. So just to give you an overview of what we're going to talk about today, Pam's going to start off and just give a general overview of the benefits and the eligibility. And I do just want to say, sort of as a footnote, that this isn't a begin from the beginning and talk about every benefit provided by the PFML, because we're assuming that most of you listening have been paying some attention to this for the last couple of years. And so what we're going to try to do today, as you see in the second bullet, is highlight from the recently amended PFML regulations what the changes are, what you need to be concerned about, and what questions are raised. And just to put it in context, after the PFML was passed, there were regulations issued in June of 2018, and those regulations were issued after an extensive comment period. And then those regulations just sort of sat there literally for 2 years. And then what we saw in July was the DFML revised certain aspects of those regulations. And so that's really what the focus is going to be this morning. And then we'll wrap up before the questions with a planning checklist, things that you should be considering now as you get ready for January 2021. So without further ado, I'll turn it over to you, Pam.
Okay, great. Thanks, Nan. So just by way of, setting the context, and really a reminder, this chart here shows the different qualifying reasons for paid family medical leave, as well as the maximum number of weeks that are available. So starting with medical, the maximum amount of leave available there is 20 weeks. For family, birth, adoption, or foster care, which is, bonding with a child for, the 12 months, the maximum leave is 12 weeks. The same for family, to care for a family member with a serious health condition, 12 weeks. And in the case of caring for a family member who is a service member, the maximum is 26 weeks. And for caring for a family member whose active duty is pending, which is called qualifying exigency. And I forever have to practice pronouncing that word. The maximum number of weeks is 12 weeks. And then in the aggregate, the maximum is 26 weeks per benefit year. And as you can see, all of the different qualifying reasons for leave are available as of January 1st, 2021, with the exception of the family, to care for a family member who has a serious health condition. that becomes first available on July 1st. So one important note here is, so what do we mean by benefit year? So benefit year is the 52 consecutive week period beginning on the Sunday immediately preceding the first day that leave commences. And that becomes important when you think about if you're also an organization that is subject to family and medical leave, the federal Family and Medical Leave Act. That's something that will come into play that we'll talk about a little bit later on, because you may be dealing with two different benefit periods. And that's something to think about how to manage. Also, I want to make a special note as we're focusing on, the regulations and amendments to them that happened in July. One of the changes was that they changed the definition of active duty, and this is for the purposes of the qualifying exigency leave, and to include that it is active military service of the U.S. and National Guard, and here's what they added, deployed to a foreign country. So you want to be mindful of that when you're administering that type of leave. Okay, Nan. All right, so this next section, this is the part where we're going to focus on the changes, as Nan just mentioned. And let me highlight that whenever you see a little asterisk and green font, that is a term that is defined in the regulations as amended. So starting with who's covered, an employee who meets the financial eligibility test is covered under paid family medical leave. That test means that they earned at least $5,100 during the base period. The base period is the 4 quarters prior to the quarter in which the employee filed for benefits. And their wages have to be equal to or greater than 30 times the amount of weekly UI benefit. And the UI benefit, unemployment income, I probably should have said, equals 50% of the average weekly wage during the base period, not to exceed $855. Now, this an important change that happened with the final regulations here is that they clarified that wages for purposes of meeting the financial eligibility test include wages from multiple employers within that base period. And this is important, particularly, or I'm going to say particularly significant for companies like human services, healthcare, hospitality, landscaping, and other businesses where it's not uncommon that employees often work for multiple employers. And anyways, you want to keep that in mind as well if you're in that kind of industry. Now, okay, former employee. They're covered for up to 26 weeks after separation, and if they meet the financial eligibility test at the time of separation. Self-employed individuals are also covered if they've elected the coverage, first of all, and if they've made the required contributions and meet the financial eligibility test. Who's covered here? Covered contract worker. All right, so this is contingent on them meeting the financial eligibility test, that they've also have payments reported on IRS Form 1099 MISC, that they've performed services in Massachusetts and live in Massachusetts, okay? And that's distinctly different from when you have an employee. And we'll talk about that in a minute. But for covered contract workers, they have to not only perform the services in Massachusetts, but they also live in Massachusetts. And this final bullet, they do not meet the independent contractor test under Chapter 151A, which is a chapter that lists the exemptions, from the type of work that are not covered by paid family medical leave. So let me talk a little bit about this contractor test, because this is pretty key. As you probably know, Massachusetts is one of the most strict states when it comes to who you can classify as an independent contractor and pay based on a 1099 basis rather than have them on your payroll. And to meet the test, you have to, it's a 3-pronged test. Number one, they have to do the work in a way that is not under the control or direction of the employer. So that's number one. So what that means is, for example, if the employer is controlling the schedule, if the employer is controlling how they do the work, when they perform the work, where they perform the work, those are some of the factors, you know, that would come into play. The second part of the test is that the work has to be performed outside their usual course of the employer's business. So, for example, I work with some human services firms, so I'll use them as an example. So, if you hired, tried to hire a social worker as an independent contractor who's going to deliver services provided by that human services agency, they most likely are not going to be able to be classified as an independent contractor. And the reason for that is because that's the core part of what they do as a business. On the other hand, if they were to hire a bookkeeper, which is not core to their business or, you know, what they're delivering, then maybe if they meet the other part of the 3-pronged test, they could be classified as an independent contractor. The third part, or the third prong of this, is the work is done by someone who has their own independent business and trade doing that kind of work. So if you're, so what you're looking for there is that the individual is actually holding themselves out to do work for other organizations in that type of business that you're hiring them for. If you're hiring them, for example, you know, 40 hours a week, you know, and they're there for, you know, a couple of years, guess what? That's an employee, not an independent contractor. So pay close attention. There are, of course, very stiff penalties if you misclassify on this. And so anyway, more on that. We can roll to the next slide. All right, so I think we covered this first bullet in the last slide. So I'll jump right to temporary employees. So temporary employees are also covered, as well as seasonal employees, if they meet that financial eligibility test. Okay, workers provided by staffing firms may be covered individuals as well. The issue here is what you need to think about is who is the employer or the covered business entity with respect to these workers that are coming from staffing agencies. So under the regulations, it says that an individual employer is determined by the FEIN number. So that might mean, you know, that the staffing agency would be the employer. That said, you want to make sure the responsibility for PFML contributions is clearly addressed in your agreement with the staffing firm, just to avoid liability based on joint employer. Out-of-state workers. Okay, so if services are performed localized in Massachusetts, they're covered. And just a couple of bullet points on this one. The services are localized, and this is a really complicated, by the way, piece of, you know, so if you're trying to figure this out, recommend you talk to somebody who has expertise in this. But anyway, the service is localized if performed entirely within Massachusetts, or services performed both within and without Massachusetts, but services performed without Massachusetts are incidental. And examples would be services performed without Massachusetts are temporary or transitory in nature, or performed without Massachusetts consist of isolated transactions. So going to the next slide. Okay. So the services, again, out of state, who's covered. Services performed are not localized in any state. So if they're not localized in any state, but some part is performed in Massachusetts and the base of operations is in Massachusetts, or absent a base of operations, the place where the services are directed or controlled. You can see why this is pretty complicated, right? And then the base of operations or place from which services are directed or controlled is not in any state where some part of the services are performed, but the worker's residence is in Massachusetts. And let's go to the next slide, because the real point about all of this is remote workers. Hello, here we are in the land of the new norm of, we have tons of remote workers. I know a lot of my clients have remote workers, and and remote workers that are have been doing their work in Massachusetts, but live in New Hampshire, for example. So remote workers may become an issue when Massachusetts workers work remotely, from outside Massachusetts. And, when you think about it, like I work with one of my clients is an engineering firm, and they have, always had workers, working within their facilities. When COVID hit back in March, they're all set up now to work remote. But who would think that 6 months later, we're still working remote, back in March, I don't know that we all anticipated that this could be longer term than what we thought. So that becomes a little now muddy. So you want to consider a framework establishing when work localized in Massachusetts. By the way, it's not just a paid family medical leave issue. There's other issues involved with this whole remote worker thing, like withholding unemployment, workers' compensation. And I'll using the example of, someone working, living and now working in New Hampshire, for months on end. In this case, you may have employees saying, oh, wait a minute, I live in New Hampshire, no state taxes, right? And so now that I've been working most of this year, remote, why do I have to pay Massachusetts taxes? So those are the kinds of issues that can start coming up around remote workers. Now let's go to the next slide. Okay, let me make one more point about the remote workers. The other thing to consider too is, and I'll use this client example, is they're now, because the remote working situation has been so successful, now talking about having their workers remain, or many of their workers remain on a remote working schedule in order to cut their overhead, for example, on leases and renting and all that kind of good stuff. So if that happens, then that probably does change the dynamics of paid family medical leave, as well as the whole tax situation. So just want to bring that to the forefront too. Okay, back to the other slide.
Am I going to pick it up here, Pam?
There you go.
Yeah. And I just want to follow up too, because I think Pam's point on the remote workers is this is all in flux right now, and as Pam indicated, to the point that employers are saying, hey, maybe we'll make some of this permanent. I think the thought has to be, is this a situation where workers are not localized in any particular state, but some part of the service is performed in Massachusetts? And if somebody's living in New Hampshire and is remote, maybe some part of the service is not performed in Massachusetts. And so, those individuals wouldn't be subject to the PFML. However, there's all sorts of other issues, not the least of which are tax and withholding issues. And as Pam and I were talking about yesterday, we both have a number of clients who are saying, should we make these these situations permanent. In some cases, employees are clamoring for it to be permanent. They don't want to commute anymore. They like the situation. And you really have to consider, the tax issues. And perhaps some of you, that have employees working in multiple states are familiar with these issues. But in this particular situation, you have to think about it. I think for now, and I'll just go back and then I'll move on, that for services that were performed entirely in Massachusetts before the pandemic, I think that now we can look and say, well, okay, if somebody's working in New Hampshire, the services are performed both within and without, and the services without are incidental because they're temporary. And temporary doesn't necessarily mean short. I mean, temporary could mean 8 months or 9 months or 12 months of the pandemic. So I think that remote work in a pandemic might fit, also within this slot. But as Pam indicated at the outset, this is a complex area. It's addressed sort of very briefly in the beginning part of the regulations. And, if any of you attended any of the DFML listening sessions, or even the session, gosh, we did 2 years ago at the chamber, you can remember folks from the DFML giving examples of people, half the work in New Hampshire, half the work in Massachusetts. So it's not an easy area to, to navigate, but this is the general outline.
Thanks, Nan.
All right. Yeah. So moving on to another topic addressed in the regulations, and this is, I think what we've all been talking and thinking about really since the inception of the PFML, and now the rubber's kind of hitting the road. If you haven't already, you need to start thinking about how this program is going to integrate with your existing policies, existing programs that you have, existing benefits that you provide. And interestingly, in the regulations that just came out at the end of July, there was a new definition, and the definition in this section was called job protected leave. And it basically provided that any leave that you provide under a temporary disability policy or program, under a paid family or medical leave policy, or in an extended illness leave bank, that leave runs concurrently with the PFML. And so you're probably all thinking, wait a minute, we have all these leaves and I thought it didn't run concurrently, and what is this talking about, and is this a change? Sort of. And really what they're saying here is if employers have policies, and you'll see this in a few minutes, if you have a policy separate and apart from sort of normal accrued leave, we're not talking about vacation here, we're not talking about sick time, holidays, PTO, anything like that. We're talking about a temporary disability policy, which, by the way, when the PFML uses the term temporary disability policy, they're referring to a short-term disability policy. So if you have a temporary disability policy, if you have a separate paid family or medical leave policy, again, this is not an existing sick time or vacation or anything like that. You have a separate policy that's paying benefits for the same reasons as PFML, or you have an extended illness leave bank. Payment out of those benefit buckets, if you will, is going to run concurrently with the PFML. And the regulations do define extended illness leave bank, and some of you, if you don't have one, are probably familiar with the concept, but it's a voluntary program where individuals can donate accrued leave then that other coworkers could then take advantage of if they've maxed out of various leave entitlements. All right. I have an asterisk next to extended illness leave bank, just because throughout the course of the regulations, this is sometimes referred to as an extended illness leave bank, sometimes referred to as an extended illness leave program. The terms seem to be used interchangeably. That kind of stuff just drives me crazy, but I just wanted to, to the extent some of you are looking at the regulations and you see the two terms, it appears that the terms are interchangeable. All right, and so here's what I was talking about before. Let's just call it generic or garden variety accrued paid leave that most of you probably have. And so this is paid leave separate and apart from a short-term disability policy, another paid family or medical leave policy, or an extended illness leave bank. This is the leave, your sick time, and it can be, it's called many different things amongst many different employers, but sick time, annual leave, vacation leave, personal leave, comp leave, paid time off, leave from an extended illness leave program. Let me come back to that. But basically what the regulations say, these types of leave can run concurrently with PFML. They may run concurrently with PFML, but it's only when employees choose to use such leave. In other words, if employees want to use that leave as opposed to a PFML benefit, why would an employee want to do this? Because they'd want to get 100% wage replacement versus what the PFML benefit provides. So employees can choose to use this leave. And in order for employers to run it concurrently with the PFML leave, you need to inform employees that if they do choose the leave, that it will run concurrently. So two criteria there. You need to have a policy that says, hey, listen, employees, if you choose to use your vacation, sick, personal time for PFML, you can do that, but it's going to run concurrently with the PFML. And so the thing to keep in mind here, this is employee choice. Unlike under the FMLA, we can't mandate it as employers. We can't require employees to exhaust this leave, but they can choose to do so. And once they choose to do so, we can run it concurrently with the PFML. The reason I asterisked here the extended illness leave program is because there is an inherent tension here where they put this program in with the list of accrued paid leave. And as you saw on the previous slide, let me go back, sorry. Previous slide, under the definition of job protected leave, any leave under an extended illness leave bank would sort of de facto run concurrently. But here it says, listen, the employee has to choose such leave. Probably not going to be a big issue because if an employee is in an extended illness leave program, he or she is probably choosing to take that leave where they're maxed out of benefits. But there's a couple of more than a couple of inherent tensions within these regulations, and some of it, candidly, is just going to have to play out as the program rolls out on January 1st or even before. All right. So in the regulatory provisions, there are provisions that provide both for when an employee's benefit amount from the PFML may be reduced, and there are sort of mirror provisions that provide for when an employer may be reimbursed for paying some of these benefits if the benefits are paid for out of, say, that short-term disability bucket that we just talked about, or a paid family and medical leave policy bucket that we talked about. And we'll talk about the reimbursement one in a moment, but I just want to point out these provisions. And again, these provisions don't necessarily work nicely or harmoniously together. So I'll just say at the threshold that this is something that's going to have to be worked out as the program implementation rolls out. I have spoken with individuals at DFML about these provisions, and so the information that I'm providing to you right now is the latest information that I have. And I also just want to say, Pam, and I probably should have said this at the beginning, throughout this presentation, we're talking about employees and employers, and we're using the term employee generally to cover covered individuals, which includes covered contract workers, self-employed individuals, and former employees. So we're just using that general term to cover all of those categories, just to keep it simple. All right. So if an employee applies for and is receiving the benefit under PFML, that the Department of Family and Medical Leave is going to reduce that benefit, and this is provided in both the statute and the regulations. They're going to reduce that benefit by any unemployment benefits the individual receives and by any workers' comp, unless the individual is getting workers' comp for permanent partial disability, for some injury prior to the PFML application. The PFML benefit is also going to be reduced by other state or federal temporary or permanent disability benefits laws. And what they mean here are like the Social Security disability income, SSDI, or the supplemental security income, SSI. And the benefit also may be reduced by an employment's permanent disability policy or program. And while I haven't got 100% confirmation from DFML on this permanent disability policy or program likely refers to long-term disability. It's important to keep in mind as an employer, what this means is that if employees are getting payments out of these particular buckets, it really has nothing to do with you as an employer. Let's say you have a long-term disability policy, the benefit reduction is going to be felt by the employee, and it's the DFML that's going to be paying, a lesser benefit. So there's no offset in this particular case for employer provided benefits. All right. And interestingly enough, segue on that is that if an employee is receiving benefits from the department, their weekly benefit is not going to be reduced by a short-term disability policy or program that you have that might be paying out benefits. It's not going to be reduced by a separate paid family or medical leave policy that you have and that might be paying out benefits. And it's not going to be reduced by wages paid for another employer or self-employment, unless the aggregate of those benefits, so the PFML benefit and let's just take the first bullet, the short-term disability policy, if those benefits exceed the employee's average weekly wage, then the employee's benefit is going to be reduced down to his or her average weekly wage. This is not the state average weekly wage. This calculation is tailored to what the employee's average weekly wage is. So those are the reduction provisions. And I know many of you are probably saying, well, why would we have those policies? And why would we be paying benefits? And why would we be paying benefits, where the employee could be, potentially, I don't know, let's use the word double dipping. Well, there's a couple reasons why you might want to do that. And one of them is that if your goal is to supplement wage replacement or provide wage replacement at 100%, that might be why you do it. Do you have to do it? No. Is it a good HR practice? That, that's something that you have to decide. But those are the reduction rules. And again, this is a reduction that the DFML gets, okay? They're in some ways, getting credit for your benefit supplementation.
And then just to add to that, another reason, for considering that too is when the paid family medical leave benefit for those that are low, the income replacement ratios are different for those based on pay. So if you have a higher paid employee, that replacement ratio might be as low as, 40%, 30%. And that would be a good reason to have some of those policies in place compared to if you have lower wage workers, their replacement income replacement ratio may be as high as 80%.
Right. And that's a good point. And I know that, as we've done these programs on PFML, one of the questions that we always get is whether it's for a highly compensated employee or an employee that's getting a wage replacement at 80% under the PFML, can employees supplement this benefit with their accrued time off? And again, now we're talking about the vacation, holiday, personal time. And the DFML, and I'm going to talk about this in a little more detail in a minute or two, the DFML is clear that their benefit cannot be supplemented. So this is perhaps a way to accomplish that if from an HR perspective, you want to do that. But, sort of juxtapose that against the reimbursement provisions in the regulations. And so this is, and when we first saw the statutory provision, 175M section 3C, there was just one line about reimbursement. And even the regulations that came out in June of 2018 referenced reimbursement, but it didn't really talk about how it was going to work or when you got reimbursed. And it was, it was something that was out there. And even when you went to the DFML listening sessions, they sort of said, oh yeah, we'll figure that out, as the time approaches. And so there has been some elaboration around reimbursement, but I was yesterday talking to someone at the DFML, and she indicated that we haven't figured that all out yet, and that'll be coming in the next few weeks. And frankly, I don't have 100% confidence that's going to be figured out by January 1, but here's what we know right now. So if you're an employer and you're making payments to employees that are greater than or equal to the weekly benefit amount that an employee would be getting under the PFML, and you're making these payments from one of three buckets: your short-term disability policy, a separate paid family and medical leave policy, or an extended illness leave bank, then you can get reimbursed for those benefit payments. We don't know how much you're going to get reimbursed. We do know on the second bullet that you have to provide evidence that the payments were made consistent with PFML requirements, so meaning that the employee got at least the benefit that would have been provided under the PFML. So really what we do know now is for reimbursement, there's two criteria. The payments have to be granted to employees for PFML qualifying reasons, and the payments have to be made out of separate types of leave, separate buckets of leave, other than your generic annual paid leave. I'm calling it generic, but other than annual paid leave or accrued paid leave, such as sick holiday vacation. And accrued paid leave, that's specifically defined in the regulations. So again, employers can potentially get reimbursed for these payments. This is separate and apart from either self-insuring or buying insurance, buying private plan insurance on the insurance market. If you have a policy, you're not self-insured, you're not buying insurance, this is just a separate policy. You're making contributions, by the way, to the trust fund, but you have this policy, you pay out under the policy, you can get reimbursed. Now, one thing I want to say here is, and you're probably thinking like, okay, if we do this, if we're paying employees, again, if we're paying them pursuant to a policy or program, can we let employees supplement their benefit amount, whether they're getting paid by the DFML, whether they're getting paid by us, can we let them supplement a benefit amount with their accrued paid time off to bring them up to 100% wage replacement? And I'll say at the outset that this is not specifically addressed in either the regulations or the statutory provision. And I will also say that the DFML's position, right now on November 19th, 2020, is that supplementation of a benefit amount, whether the employee is getting paid from DFML or otherwise, if an employee supplements his or her benefit with, paid sick time, paid earned time off, or vacation, that's not permissible according to the PFML. And their rationale or their logic, if I understand it, is that the benefit maxes out at $850. And as Pam just mentioned, it's a formula based on an employee's average weekly wage, and there's a calculation. And once that calculation gets to $850, the benefit maxes out. So for some lower wage workers, their wage replacement is going to be in the 80% range. Obviously, the higher wage earner you get, the lower the benefit ratio is going to get into, down into the 30% range. So what the DFML says, listen, employer, you can allow employees to supplement, but if you do that, it's going to reduce the number of days they've been approved for leave, and it can jeopardize your employer reimbursement under this particular provision. So said another way, for that second point that I just made, if you're paying or making payments under a temporary disability policy or out of a paid family and medical leave policy, and it's not 100% wage replacement, and you say to an employee, oh, well, you can supplement this policy with your accrued time off, you've just thrown your reimbursement chances out the window. And so, as I've thought about this, and actually as Pam and I have talked about this over the last few days, we've sort of asked ourselves, well, who's the DFML to tell us, how these benefits, can be paid, or whether we can let employees supplement? And the answer to the question is, maybe they can't tell us, but they can certainly have integration provisions, in their regulatory scheme with how payments that employers make work with payments that they're making. So that's where it is today. And I do think that we all just ought to be mindful of it, because every time we do one of these webinars, some of the questions are, can employees supplement? Can we let employees supplement? And I have to say right now, from the DFML perspective, the answer is no, you can't supplement. And the last thing I'd say is with respect to these two provisions, gosh, you can get reimbursed, you know, if you pay benefits out of this bucket, versus the DFML is not going to reduce a weekly benefit if there's a temporary disability program. When you look at the regulations, there is mechanisms for communications between the DFML and the employer at the outset of the benefit period and or the leave period. And one of the questions that the DFML asks, or one of the pieces of information it seeks, is, are you, employer, paying benefits out of one of these programs? And I think it's at that point in time that if you do have one of these programs or policies, you got to let the DFML know and say, hey, listen, how do we get reimbursed for this? What, you know, we're making this payment. We want to get reimbursed. We made our contributions. You know, we feel that this money should come back to us. So I think that's the best advice that we can give right now. So this is a slide that I'm thinking is familiar to most of you, and I'm not going to spend a lot of time on it, but you know, again, we have to think of the PFMLs we just discussed in the context of our existing policies, but also in the context of other laws. And we know by now that the Federal Family Medical Leave Act and the Massachusetts Parental Leave Act runs concurrently with the Mass PFML. And so the lesson here is that your policies need to be integrated so that it's clearly established that when somebody, for example, is taking FMLA leave for PFMLA qualifying reason, you're going to run both of those leaves concurrently. Well, Pam, we'll talk about the benefit year and maybe lining those up in a couple of minutes. But the other thing too is that, you know, as you look at all these potential leave laws, you know, certainly they're not all going to run concurrently, but in any case, extension of leave under PFML, FMLA, could be deemed to be a reasonable accommodation, and that's why you see that provision on there. It's interesting because the first of 3 iterations of the regulations indicated that earned sick time, which is 40 hours, you know, in Massachusetts state law, would run concurrently. And that really dropped out of the regulations. And I guess what I would say about that is there may be some situations when it can, but where the mass earned sick time can be available to go to medical appointments or for domestic violence, you know, maybe it's more of a case-by-case basis. All right, and then just getting into some of the other changes, and we're calling this nuts and bolts because this is just sort of some of the nitty-gritty kind of granular aspects of the regulations where we saw some changes. The DFML has recently confirmed, and the website's consistent with this, they will not accept applications. Actually, I'm jumping ahead to the third bullet, sorry. They're not accepting any applications at this time. The program goes live on, oh gosh, horrible typo there, 1/1/2021. So that's when the program goes live. The website did reflect earlier that employees could apply for bonding leave as of December 2nd of 2021. But I was told that date has been changed. It's to be determined, and they're not sure if there's going to be any applications that people can submit before 1/1/2021. There are no forms to see online, so we don't really know what this application looks like yet. But going back to the first bullet, DFML is not going to accept an application until basically the employee, the applicant, proves that it notified you, the employer. So I think that's good news because, you know, some employers were expressing concerns that how are they going to know an employee even, you know, applied for this? And DFML, there is a regulatory change that said DFML may allow an employer to submit an application for benefits on behalf of an employee. Now, we don't really know exactly what this means, but one of the things that it teaches me, or a takeaway I have, is that if now you're going to know exactly when an employee is applying, and maybe you can even apply for them, maybe. I mean, it says may, and the regulations say may, so it's not, you know, it's not 100% certain. but that feels like it's getting awfully close to an FMLA designation for me. And this to me is a reason to seriously consider, and I'll just say as a footnote, Pam wholeheartedly endorses this, having your benefit year, your leave year for the FMLA and the PFML be the same. That doesn't mean you get to pick one of the 4 years, because the PFML specifically states the benefit year has to be the forward-looking year, okay? Starting when the leave starts looking forward 12 months. That's one of the 4 choices under the FMLA. So I just think it makes a lot of sense to give serious consideration to running those leave years, making those leave years the same, because then you'll have, it will be easier, to the extent you're subject to the FMLA, it will be easier to run the leave concurrently, and also to draw down the FMLA leave at the same time as the PFML leave. Now, if you're not already in a forward-looking leave year for the FMLA, obviously you have to give employees 60 days notice if you want to change, and employees can't be impacted negatively because of that transition. Said another way, they can't lose leave because of the transition. So, could be a little bit of a bumpy road as you transition there, but that's something to consider. Please, everybody, change that typo on your slide. 1/1/2021. I think I was just overtaken by the 21s there. So, all right. These next couple slides, I'm not going to talk a lot about. I highlight them here only because this was completely new in the July 2020 regulations. So basically, the regs recognize that substance use disorder may very well be a serious health condition. So if somebody's getting treated for that, they're eligible for PFML. Obviously, and consistent with other disability law, absence because of use of the substance isn't protected leave. And I thought this was interesting. It says treatment doesn't prevent an employer from taking action against an employee if there's an established policy applied in a non-discriminatory manner, communicated to everybody, that provides for termination for substance use in certain circumstances. So you're thinking, what is this? When is this applicable? And I think about intermittent leave for someone in substance use disorder. Perhaps they're attending a program or certain types of treatment, and so if it's intermittent leave or a reduced leave schedule, they may be in the workplace intermittently or less time. And so, for example, if they're impaired during the course of a workday or something like that, the fact that they're on PFML intermittent leave, assuming that you have a policy that's consistently applied, isn't going to preclude you taking action in accordance with that policy. And then, just by way of completeness, leave to take care of a family member who is receiving treatment for substance abuse is also covered PFML leave, but as Pam mentioned at the outset, that coverage isn't available until July. All right, talking about private plan exemptions, and I know, gosh, I haven't done a formal survey, but I know many employers are going either self-insured or purchasing private insurance. And here, these provisions, I think, help answer some of the questions. Well, if somebody shows up and is our employee and maybe, shortly after they show up, they haven't made the requisite number of wages with us to meet the financial eligibility test, they apply for leave. How do we know if they have the Massachusetts wages? And the regulations here said, you can ask them. You can require them to verify the wages. Sort of a double standard here with these next 2 bullets. If your private plan denies leave to an employee, the employee can appeal to the DFML. And if they don't like the result they got at DFML, the employee can apply to district court. You don't have as many rights. If a private plan or self-insured denies the benefit and the employee appeals to the DFML, you're stuck with the DFML interpretation. In other words, you don't have a further right of appeal to district court in this situation. Got to keep your records for 3 years. And there are some enhanced penalties in the new regulations for failing to maintain the plan, provide the benefits, and do everything you're supposed to do to make sure the benefits identically mirror the benefits that employees get through the state plan. Okay, former employee provisions. Again, I've gotten a lot of questions about this from employers who are insuring, and they say, okay, you know, what if, what if somebody's unemployed and during that 26-week period, they have a PFML condition, who do they file with? And the answer is, if the employee remains unemployed, they file with you. But you can certainly ask the employee whether or not he or she is currently employed, because if they're currently employed, the benefit application would go to that subsequent employer. And then let's just say, you have a new employee coming on board. As I said previously, you can require that new employee to provide wage verification if they apply for leave to determine or make sure they meet the financial eligibility test. Okay, for those of you who have been living with the FMLA since, I think, 1994, I was a lot younger then when that law came into effect. Intermittent leave and or reduced leave schedule has been very, very difficult to manage. And, what is it, 26 years later, a quarter of a century later, right? I'm still getting questions. Do we really have to do this? This is, impeding our operations. I can't do this. And I think in these next two slides, there's actually 4 different places in the regulations where the DFML addresses intermittent leave, and which I think is very interesting. But I think it's their effort to try to, I don't know, mitigate the impact. But first, to receive intermittent leave benefit payments, the employee has to verify with DFML each week hours of leave taken. So each week there has to be a verification, all right? Consistent with the FMLA, intermittent leave increments, in other words, what's the smallest increment of time you pay? That has to be consistent with your other policies, but DFML, similar to under the FMLA, is not going to pay in increments of less than 15 minutes. This is actually a change from the prior regulations, which said that employers could have increments no greater than 4 hours, which is basically a half day. We see it ratcheted down to 15 minutes here. All right, so if the use of intermittent leave is inconsistent with DFML approval, so let's say there was a certain number of times or a certain reason, if it's inconsistent, said another way, if you feel like the intermittent leave is being abused, it's not retaliation for you to request additional information. So good news is you can ask questions, and we know this is in response to the stringent retaliation provisions in this law. And then again, if an employee on an intermittent or reduced leave schedule fails to work during the times agreed to, the employee may be subject to discipline. And this is interesting because this provision appears in both the intermittent leave section and in the retaliation section. So it kind of is emphasizing that if employees are abusing, I'm just going to use that word, it's not a regulatory term, then you may be able to discipline them. Obviously, proceed with caution, get advice, but the regulatory provision is there. Okay, medical recertification. This basically mirrors the FMLA. You can get recert after the time period, the initial period of incapacity, or after 6 months if the initial period of incapacity is longer than 6 months. And then finally, before we go to checklist, we all are familiar with this retaliation provision and the fact that if anything bad happens to the employee within 6 months of the leave, there is a presumption that it's retaliation for taking the leave, and the employer can only rebut that presumption with clear and convincing evidence. Well, the third bullet here is an addition to the regs that showed up in July of 2020, and it said application of a pre-existing employment rule or policy shall be deemed to be clear and convincing evidence. Footnote, if you have, or maybe not a footnote, a header, if you have of an existing policy, a discipline policy, a code of conduct, expectation policy, and you apply that policy, within that 6-month period, it's a performance issue, it's a, whatever issue, that's deemed to be clear and convincing evidence, which is can rebut the presumption that there was retaliation. So what that underscores is the importance of having policies and applying them, having job descriptions that outline and set forth what the expectations are, because that's really, really, really going to be looked at. All right, and now I'm going to turn it back over to Pam to talk about what you should be doing now.
Great, thank you, Nan. If anyone has heard me speak before, you know I am a checklist queen. So here are some items that you want to consider. And we say consider rather than definitely do, because it's really going to depend on your particular business. But here are some things to consider. So the first one, which Nan already touched on and we touched on previously, is really taking a look. If you're subject to FMLA as well as PFML, really take a look at that, making the family medical leave benefit period, the same as PFML. One reason to consider that is just even to reduce administration, especially in terms of designating leaves. And if you're looking at two different benefit periods, it's not only a task to figure it out, but it's also probably going to be confusing to your employees. So that's the first thing. Another item to consider in preparing for 2021 is to review your paid time off programs to determine how best to coordinate them with PFML. For example, if you provide, paid sick days that are more generous than the Massachusetts earned sick time requirements, and you have a huge amount of, sick time accrued in big banks, you may want to, consider going forward whether to design that program differently. Next slide. Okay. So under PFML, as we mentioned, lower paid individuals receive a higher percent of income replacement than higher paid individuals. And, so you may want to review your time off programs and disability insurance policies and consider, changes that you might want to make. We suggest, talk with your broker about disability insurance policies, that may be better designed to coordinate with PFML. To give you an example of that, some organizations might have a short-term disability insurance policy that covers 3 months, 90 days, with long-term kicking in on the 91st day. Also common would be short-term disability policy lasting 6 months and long-term picking up, after the 6 months. So you may want to look at those time periods, because medical leave, the maximum available is 20 weeks, which would fall short if you had 90 days of short-term insurance coverage. And you may want that long-term policy likewise to pick up, after the 20 weeks, and just, again, just look at the whole design and integration of the programs as Nan had touched on earlier. Another checklist item would be review your leave programs to establish what leaves can run concurrently. You want to be really clear about that. And when they don't, by the way, so for example, PFML may run concurrently with FMLA, as well as Massachusetts parental leave. This is important, in terms of to avoid stacking one leave on top of another. But to give you an example of when they may not, for example, under paid family medical leave, a family member, definition of a family member is defined far more broadly than how it's defined under the Family Medical Leave Act. So it's very possible, for example, under paid family medical leave to take leave, let's say, for example, to care for someone's grandmother. Now that's not available till July 1st, as a reminder there. But when we get to that point, that is not leave that would qualify as leave or a qualifying reason under the FMLA. So you would not be able to run it concurrently in that kind of case. And that's something, again, to consider. And to be really clear what your process is around that. Another checklist item here is for family leave to bond with a newborn or a child placed for adoption or foster care with an employee. Determine whether your business will agree to intermittent leave, and if so, under what circumstances. So you have the option there, you know, to consider treating that as intermittent leave, you know, and there might be good reasons to allow for it. But you need to be clear and again, administer that in a way that is consistent and equitable. Next slide. Also, you want to identify potential administrative issues up front, including how PFML will be tracked, communicated to employees, who in your organization will be responsible for responding to DFML requests for information around claim adjudications, and which, by the way, have to be provided to DFML within 10 business days. So, you know, you want to be clear around that. Also, consider updating your employee handbooks and policies as needed to reflect any changes due to the Massachusetts PFML, including, by the way, adding a substance abuse policy or revising an existing policy. And lastly, make sure you provide some management training, including how requests for leave will be handled, and also around those anti-retaliation provisions. It's really important for managers to understand that. So that's our checklist.
And I just, the only thing I want to add to the checklist is that second to last bullet, updating employee handbooks and policies. And, you know, I know many employers are looking at this as an opportunity to update. And so I would just put in a plug there. This has nothing to do with PFML, but everything to do with reasonable accommodation. And I think those policies, it's clear that the MCAD, I was listening to a panel that the MCAD chairwoman was on the other day, and as some of you might have seen a couple of weeks ago, disability cases are the majority of cases at the MCAD. Reasonable accommodation are the majority of disability cases. And so, you know, what they're saying is most of those disability discrimination cases are when there's a failure to reasonably accommodate. And so I think here, where you're talking about serious health conditions that in many cases may also be disabilities and trigger the reasonable accommodation requirement, that's a policy. You know, if you only look at two aspects, your leave policies and something else, look at your reasonable accommodation. So my 2 cents.
Good point. Good point. Next, I think this concludes.
I think that's the end. Is that the end?
Yeah. That's it.
That's the end of the presentation.
Questions now.
So Nan, do you want to shut off your screen?
Sure.
We actually do have a question in the chat from Suzanne. Let's see. We offer a ST-DIS policy, but is completely employee funded and voluntary. We, the employer, do not fund any employee enrollment. It is a private policy through Illinois Mutual. So would that run concurrently with PFML as well?
I think it would depend on the policy, and you're gonna have a situation there, which would the question would be whether or not the employee's benefits would be reduced. Like, in other words, if the employee was paid benefits out of that policy at the same time that the employee was getting a benefit from DFML, and that benefit exceeded what the employee was making average weekly wage, then it might be reduced. And this is exactly the situation where I would say for that employer is that, you know, when an employee is making application, indicate that you are paying benefits out of this STD policy, and you very well may be eligible for reimbursement. You know, where it's an employer provided policy, the regulations don't say it has to be employer funded. So.
Okay.
Just to add to that, I think the way to think about it is whether it's truly employer sponsored, you know, in basically an ERISA plan. You'd want to look at, I mean, if this is a truly voluntary program under which really the employer is just simply providing the convenience of allowing the employee to pay for their own individual coverage. If that's the case, I think that would not run concurrently. So I think you'd have to, again, as Nan said, it depends on the policy and how it's, you know, whether it's really employer sponsored or just a payroll, you know, withholding mechanism.
Yeah, and I think too, a follow on to that with respect to, you know, whether or not like PFML benefits can be paid with pre-tax dollars, right? There's no guidance on that yet, and there's no definition really regarding, you know, what a short-term disability policy is. Let me just look quickly here and see. Yeah, temporary disability policy isn't even defined in the regulations, so they're really, that's why, and I know I'm not, you know, we're not trying to evade the question here, but that's why I think that communication at the outset of that leave to say, here's what we have, what bucket does it fit into? Is the benefit going to be reduced? Are we going to get reimbursed? How can we get reimbursed? And, you know, unfortunately, I think Suzanne, who asked that question, we just don't have a firm answer to that yet.
Okay. Mark asks, former employees who apply for PFML, how is the former employer impacted? Is it an experience rating hit?
You want to take that, Pam?
Sure. The short answer is no, because the contributions are, you know, apply across the board, you know, to all employers. They're not experience rated like unemployment benefits.
Chris asks, can you please clarify whether or not employees can use vacation/sick time to supplement the weekly pay they are receiving for PFML? For example, if an employee makes $1,000 per week and receives $850 from PFML, can they use their own time to make up the difference?
There's a really short answer to that question. No, DFML does not permit it. And what the DFML says now is that if that happens, that the employee's leave allotment is going to be shortened, and in a situation, well, that wouldn't be a situation where an employer could be reimbursed. But the DFML's adamant position is that this is a program or a scheme, a legislative scheme that provides a maximum benefit of $850, and we do not allow supplementation. And so that's, you know, I'm not agreeing or disagreeing with that. I'm telling you that's what their position is.
Any other questions? Raise your hand, put in the chat. Well,
actually, we have a question. I just can't find the raise your hand button.
It's okay, we can hear you.
Go ahead, you can ask your question. So employers are protected against retaliation. But what if an employee, say, gets a negative review and then a week later they're filing a leave application? Is there protection for the employer in a case like that?
Well, I mean, in that case, that's actually good news for the employer because you know, a key component in proving retaliation is temporal proximity. So take the reverse of your example. Let's say an employee provides for leave or applies for leave and a week later gets a negative performance review. Well, that employee could claim, wait a minute, the only reason I got the negative performance review was because I applied for leave. But in your scenario, that's a best case scenario. Well, not best case, but you know, the employee got a negative performance evaluation and then he or she applies for leave. It would be very difficult to connect the dots there and say, they'd almost have to prove that you knew they were going to apply for leave, and so you gave them a negative performance evaluation. But that, and that's exactly what that regulatory addition contemplates, is that irrespective of a request for leave, you would have taken the action that you took. So take the mirror of that or the reverse of that. An employee provides for leave, and in the normal course of the annual performance review, it's time to do the performance review the next week, and the performance review is a negative performance review. As long as that can be substantiated, it's not retaliation. Can an employee make a claim of retaliation or bring one? Sure, we can't stop that, but there's a tension there between consistently administering policies, right, and being mindful of, once that employee requests leave, they have the ability to, assert a retaliation claim.
Okay. I had another question. Just to clarify a little bit about the use of your own time off. So, we have a number of employees here who, and we're going to go with a private plan for the paid family medical. But so we have people that are allowed, well, we are all allowed to have like a banked sick time. If you don't use your sick time for the year, it rolls into a bank and you can use that in the event that you have to be out for an extended period of time. But we have people here that have a lot of bank time off. So if somebody were to go out on a leave of absence for, if they're having an operation and they need time to recuperate, sometimes they'll elect to use that and get their full pay. In the scenario of the paid family medical, when does the clock start ticking for that leave? So if I were to go out and just use 6 weeks of my own paid time off in the form of my bank sick time, am I still considered to be on leave at that point, or does the paid family medical leave kick in after I've used that time?
Well, that can depend. And certainly to answer your second question first, it could be that, somebody exhausts, let's say they're having a surgical procedure and a long recovery, they exhaust their bank sick time and then they still need leave. That could be a PFML qualifying event. However, in that case, the regulatory provisions do provide that if an employee chooses to use their accrued sick time, in your case, or accrued vacation time for a lengthy serious health condition, if the employee chooses that, and as long as your policy says, that if you choose that, it's going to run concurrently with PFML, you can run that concurrently. You just can't require an employee to do that. So what you do is change your employee handbook and say, hey, listen, if you want to use your accrued leave for a PFML qualifying condition, that's your choice. But if you choose that, we're going to run that concurrently with your PFML. And so that, that would be the situation there. And actually, I've forgotten the first part of your question.
I think I forgot it too.
Oh, okay. All right. Okay. And so the other point I wanted to make is that let's say, you run it concurrently and a leave is exhausted, either the accrued leave and the concurrent PFML, and the employee still needs leave. At that point, a reasonable accommodation obligation would kick in. And it's not the obligation to extend the leave, it's the obligation to engage in the interactive process to determine if you can extend the leave or whether it would be an undue hardship.
Right. And another question too, we did hear, and I'm wondering if you could confirm this, but so the mass paid family medical, that starts on January 1st. They're not taking into consideration any FMLA leaves that were taken the year prior, correct? So if I have somebody who's out right now and comes back in December from their 12 weeks of FMLA, they could apply in January to take another leave, correct?
That's correct.
It is
and
correct.
Does the condition apply? So for example, if it's trying to take a leave for a condition that occurred in 2020, is that taken into consideration? No. Okay.
No, I mean, they'd have to obviously apply for the PFML, which would require a medical certification, right? So there'd have to be, a medical certification attesting to the fact that this is a serious health condition. And again, if you think about, in the FMLA world, this would be exactly the scenario where somebody's exhausted, let's say they're 12 weeks of leave, and they still need more leave. The advice for whatever 25 years has been, we can't just cut them off and say, oh, you've used up your FMLA. And I know I sound like a broken record, you go into that reasonable accommodation analysis. But here, the fact that, and this could happen, this could be stacking at the implementation of this leave, and employees on a leave right up till 12/31, which let's just say that's the end date for some pre-existing FMLA leave, they could then apply on 1/1, for example, for 20 weeks of medical leave.
Yeah.
And so I'm sorry, I'm taking up a lot of time. but so I'll give you a real example related. We've got an employee who is out, and I know he's going to be out until January. January 1, he does not get the paid family medical because he's already out on an FMLA right now. Is that correct? Because that's what we were told.
Okay, I guess how I would look at that is that I don't see any reason why you couldn't run, let's just say, the January timeframe concurrently. And so I would think that you would want to suggest to him that he apply for the PFML, because under the FMLA, is he being paid?
Well, he's being paid through our existing short-term disability insurance, which we self-fund. So he's getting.
Well, then if he's paying for short-term disability, perhaps there's a possibility that you can get reimbursed for that.
Well, we pay for it. He doesn't pay. It's a company sponsored, so he doesn't pay.
Right, I know, but I'm saying so. I think that's exactly a situation. And again, there was a change in the regulatory provision that said, an employer may be able to make an application. But what I would suggest now is that you try to talk to somebody at the DFML, because I doubt he's going to be making an application, right? Because his short-term disability is carrying right through. But that might be a situation where I think it would be perfectly appropriate for you to, let's just call it, run that STD period concurrently with PFML, which is in effect on January 1.
Okay.
Did somebody at DFML tell you couldn't do that?
No. So we are actually we purchased a private plan.
Yeah.
So we had a conversation with the insurance carrier, and that question came up because this is what happened. I just had somebody go out, and he's going to be out through January. And so the representative at the insurance company said, no, the DFML won't accept that claim because the injury took place in 2020. So that's what we were led to understand. But I can reach out to our employment attorney too and find out.
Yeah, I mean, that's interesting to me, because there's all sorts of injuries that could take place in 2020, but that develop or create or continue a serious health condition into 2021. There's no requirement under the FMLA that an injury, took place within a specific time for a serious health condition. And the definition of under both FMLA and PFML, right? The continuing treatment is defined as, continue inpatient stay or continuing treatment by a healthcare provider, which means you have to have gone to the provider twice within 30 days of the injury. But that doesn't mean the injury has to be 30 days before, within 30 days of the FMLA.
So that's very interesting, because we have another employee who is having a scheduled C-section on December 29th. And so we were told the same thing, she probably won't be able to get the insurance. So we'll have to figure that one out.
Yeah.
Yeah.
So she was actually saying, well, maybe I should delay my C-section until the January 2nd. What would be the best benefit for her?
Okay. All right. Okay. Yeah. I think that's interesting, but I think when you step back and look at, what the statutory entitlements are, and I appreciate the fact that you're dealing with a private insurer, so they're making those determinations. But I guess I would want to be careful, about employee rights and denying those rights, because certainly, a couple of days after a C-section, she's still experiencing a serious health condition.
Exactly. All right, we'll look into that further. I appreciate your answer on that.
So Whitney Knight has a question.
Hi ladies. Just a couple quick questions. One is that thinking about like who's primary and sort of who is secondary, if you will, in terms of the pay. I know that if like somebody were to use their own time, like PTO or whatnot, that they would not get the PFML benefits. And I know that there's an offset if you have the disability like short-term disability, let's say, to kind of make you whole, if you will. PFML probably is the primary, and then the disability is the secondary. But when you guys talked about unemployment benefits and like workers' comp, we do have people obviously who may get injured at work and they get a workers' comp benefit. Is that considered like a primary payer, or is like the PFML kind of paying first in those situations? I'm just kind of curious how that coordinates with one another.
Yeah. Well, in the case of workers' comp, they wouldn't get the PFML benefit, I believe.
Oh, they wouldn't. Okay.
Yeah, and
they'd get it unless it was for well, it would the PFML amount would be reduced by the workers' comp payment.
So in that case, the workers' comp would kind of be primary in that situation.
The exception is if there's an exception, right, Nan? I'm just trying to, I don't know if we can bring up that slide. Sorry. The exception has to do with whether it's some kind of permanent disability that they already had, or I'm trying to remember the language.
Hold on, I don't know if I can.
Oh, are we able to share?
No, other than for permanent.
Can you see that? I'm sorry. Okay. Hold on a minute. Sorry about that. All right, is this the slide you're talking about, Pam?
That's it.
Yeah.
So it's reduced by the unemployment benefits and workers' comp, other than for permanent partial disability before the PFML application. It's also reduced, keep in mind, by state or federal temporary or permanent disability benefits law, and also employer permanent disability policy or program.
Yeah, and so I don't know, Whitney, if this helps too, but so the benefit is not reduced by a short-term disability policy or separate paid family and medical leave. So it's just those those offsets.
You know, we have like some people who go out on workers' comp leave and they get pay. And in those cases, we don't offer short-term disability. Our policies either kind of workers' comp pay or the short-term disability. So I was trying to figure out who would pay first in that instance. Does it make sense for them to, you know, apply for the PFML? And if they don't, should we try to run it concurrently anyway for the job protection piece, similar to FMLA, et cetera? So I was just thinking about that in my brain, as I know we do sometimes get the workers' comp leaves. Okay. Thank you.
We have a couple questions in chat. We operate on contract basis, renewed annually. If we decide not to rehire a teacher, will that be considered retaliation? Next, what if the leave time overlaps?
If you decide not to hire a teacher, may or may not be retaliation. I mean, if there's legitimate non-discriminatory reasons for making the decision, if it's sort of consistent with past practice. I know that, you know, in some educational institutions, you know, everybody's not rehired at the end of the year and then, you know, hired in September. So really, you know, that would really depend on the facts of that particular situation. And Heather, I didn't get the last part of the question.
And they just said, next, what if the leave time overlaps?
Okay, I'm not sure. I guess I'm not sure what leave time, like what.
Okay, maybe they'll follow up with additional information. And then what is the best method to notify an employee that leaves run concurrently? Do they need to fill out an application for each one, or can one application suffice for them all?
I think the best method, there's two methods. I think the first thing to do is put an employee handbook or, you know, an employee policy. But then I also think when the employee is applying for leave, give them information that outlines the conditions and requirements. And much like if you're subject to FMLA, people do. They're required to give information about the FMLA leave. And I think with respect to the leave, and I don't know if this question is, if the leave applies for both FMLA and PFML, can you use the same application, the same forms? And the answer that I have to that right now is no. It's different. The FMLA has its forms and the PFML has the forms, and it's important to sort of get credit for both of them, that both forms are filled out. And also too, it's hard, and I'm thinking about medical certification. We haven't seen the PFML forms. We know from the regulations what they're going to say, but we haven't actually seen the form. So could one form, having a health provider fill out one form be sufficient? I hope so, but I think at this point, I don't really know.
Just to add to that, one potential positive on this is that I do believe DFML has been very attentive to trying to keep things as consistent with FMLA as possible. So hopefully, when we do see the forms, they may be very similar. So that would be a good thing.
To follow up to the previous question about the teacher, what if the leave time overlaps after the end of the contract?
Oh, I see. The person is on leave. So if it's PFML leave, then we know that the leave would continue because the teacher in that case is an eligible employee for 26 weeks. With respect to the FMLA, there's not a similar provision, and where the FMLA is unpaid leave, I'm not sure that there would be, sort of negative ramifications for the employee. And if the employee was using accrued time off to get paid during FMLA, then the employee, subject to one caveat, would be eligible to use that pay. Now, if you have, sick time that's not paid out upon termination, I suppose that could be an issue, but I would be concerned about, I'd want to look closer at that, and my concern is retaliation, and I think maybe that's an HR decision that you make depending on how much more leave there is and if there is any leave in a sick bank. But I think I would need to take a look at this particular circumstances there and the reason the person was getting terminated.
Okay. Can an employee apply for PFML benefits for just a portion of their leave, i.e. when they exhaust any earned time off they may have through their employer?
They can, and that is the whole point of the choice provisions. Employees can choose to use the leave, but they don't have to. So they can. I mean, I do think if an employee is using leave for a PFML qualifying, let me step back from that, Heather. If an employee is using the leave for the PFML qualifying event, and an employer has notified the employee that such use of leave will run concurrently, it will run concurrently. Okay, but it's the employee's choice, and they're basically choosing whether they want full pay or 80% or less.
Yeah.
Do you have anything to add?
What happened in that situation is the benefit that comes from paid leave would just pick up when that accrued time or that they're using is used up. So in other words, you can think of it as the payment would be coordinated between two plans.
Okay. And then with FMLA, the organization that this person works for in the past, to subtract out the days off, such as holidays, does that same practice apply to PFML?
Oh gosh. They're not addressed in the regulations at all about holidays and stuff like that.
Okay. If they have follow-up questions to ask, is it okay for them to reach out to you to ask? Okay.
Absolutely.
So I think the emails are on the presentation that we sent yesterday. Is that correct?
The emails are not, but you know what,
Okay.
what they could do, Heather, if anybody has questions, if you email them to Heather, and
Yeah.
you can just forward them to Pam and I, and we can respond.
That'd be great. Yeah.
Yeah. Okay.
Okay. I think everyone should have received an email from me. I'll put it in the chat just in case you haven't, but you should have. Any other questions or anything else you two want to say?
Anything about anything, even if it's not PFML?
I don't know if others can see that.
Karen asks who has Advil, which I think is appropriate.
Love it.
Yes, we will be sending out a copy or at the video on, we put it up on YouTube, and then that will go out to, the address will go out to everybody who participated. And so you can come back and look everything over. And if you did not receive an email yesterday with the presentation, also let me know and we'll resend it to you.
Yeah, and the only thing I would like to say in conclusion is, you know, I do think we are going to be seeing a lot, maybe not a lot, some things from the DFML over the course of the next 4 to 5 weeks. And so, you know, to the extent Pam and I, you know, put updates or information together, you know, we'll provide them to Heather and you can put on the website. So I would just stay tuned for that. It's difficult for me to predict specifically, you know, what it's going to be, but I do think, you know, they have a fair amount of, you know, sort of logistical, mechanical work to do, not the least of which is to get an application form online and you know, to start taking applications live. But as of yesterday, you know, what I was told is nobody can apply until January 1. So I think, you know, and there is a 7-day wait period. So, you know, as we all know, so perhaps they're looking at that, you know, as a buffer. But anyway, so I guess I'm just saying, you know, stay tuned, because a lot of you had a lot of good questions, and I think I'm hopeful that some of those can be answered more concretely in the coming weeks.
Absolutely. And just to add to what Nan said, you know, when we were dealing with when PFML, you know, first rolled out, you know, there were a lot of changes that occurred, you know, over those months, just dealing with, you know, the contributions side of the, you know, this. So we expect kind of the same. The other thing is, if you have not done so already, you can sign up for DFML alerts right online at mass.gov. You know, so that's a good way. And there is a way for you to ask questions, you know, directly to them too, if you would like.
Yeah, and they to follow up on that, Pam, the question function they've changed to pure phone calls. So you can which is kind of interesting, because that, you know, before all of them were online. But I have found, you know, just in the past month or so, that they are responsive. They don't really know the answers to all the questions, but they're trying, and they elevate questions they don't know, and they also are very candid when they don't know, and say, hey, listen, you know, what do they keep saying? We're pre-launch right now, so we have to figure that out. So, you know, I would, you know, suggest anybody that you know, they avail themselves of that resource, because, you know, they are responsive. You might not like the answers you hear, but you'll hear something.
Another question came in. How far in advance does application have to be submitted to employer from employee?
So the regulations say 30 days, but certainly if there's, you know, circumstances that, you know, would excuse the 30 days, there's all sorts of, that's also built into the regulations, but basically 30 days. And the regulations provide that you know, sort of, if we're not in pre-launch, an application can be submitted, you know, 60 days, you know, before the leave period. So you would think, you know, November 1, you know, would have been the application date, but we're just waiting.
Okay. All right. I think that's it. I'm just going to talk a little bit about the Human Resources Group, which has been an advisory committee here at the Chamber for over 30 years. And our advisory team consists of 15 HR professionals of varying types of business and sizes. And they work hard to come up with the programming that we put out like this and others throughout the years. And if you have any interest in learning more, just feel free to email me about that too. We have a couple of positions that are open. So I think that's it. Anything else? Any final words? All right. Well, thank you everybody for coming.
Thank you, everybody.
Thanks, and everyone have a happy Thanksgiving in these challenging times and in the times of the gathering and travel orders. Happy Thanksgiving.
Happy Thanksgiving.
Happy Thanksgiving to all of you.
Bye, Pam.
I'm not sure whether I should just